Hello, I'm Jan Painter, and I'd like to welcome you again to our program, Politics Matters. We began Politics Matters focusing on the idea that people are their principles and that our politics therefore should reflect that concept, and yet, as we all know, it frequently does not. Today we begin a special program on the amendments to the Constitution with the idea that it might prove useful at this moment in our history to consider why they were written and, of course, what they are, how interpretations of individual amendments have evolved over time, and which ones are particularly relevant. Certain amendments, such as the First Amendment guaranteeing free speech, freedom of press, religion, etc., and the 10th Amendment examining states' rights, are frequently referred to in media without offering people any discussion as to the historical circumstances under which they came about and why they were adopted into law. Are there amendments to the Constitution which could be better understood and discussed in order for all of us to comprehend our laws, rights, and privileges more thoroughly? Today we have with us Professor Frederick Schauer, David and Mary Harrison Distinguished Professor of Law at the University of Virginia, where he teaches courses in constitutional law, evidence, and philosophy of law. Professor Schauer holds an AB and MBA from Dartmouth College and a JD from Harvard Law School. He is also Frank Stanton Professor of the First Amendment, Emeritus at the JFK Kennedy School of Government, served as academic dean and acting dean, and also taught courses in evidence and the First Amendment at Harvard Law School. Welcome, Professor Schauer.
Thank you. Delighted to be here.
Before we begin, tell us, if you would, what motivations or events brought you to the study of law? In essence, what law and politics mean to you?
The first one's a little easier than the second. I think, as with most people, I arrived at undergraduate education with only a dimly formed idea of what I wanted to do with my life. Once I realized that my initial preference for medicine was not for me intellectually or in any other way. My interest in things verbal, my interest in the forms of argument and all of that led me to think about law. So it's something I've been focused on since I was about 20 years old, I guess.
To begin our discussion of the amendments to the Constitution, give us, if you would, some of the history behind their inception.
The first 10 amendments, the ones we call the Bill of Rights, were part of in a way, compromise enacted or adopted or agreed upon at the time of the original ratification of the Constitution in 1787. Some people wanted rights to be included in the Constitution. Some didn't want them to be included in the Constitution. But the Bill of Rights, 1791, 4 years after the original Constitution, was part of this compromise. Some people agreed to go along on the assumption that shortly thereafter there would be a Bill of Rights. The important thing to remember about the Bill of Rights is that it was originally intended solely as a restriction on the federal government and not as a restriction on the states. Freedom of speech, the rights of criminal defendants, freedom of religion, and all of this were originally thought of solely in terms of federal power. The states could do what they wanted. States could establish religions, restrict speech, or do anything else. That did not change until the 14th Amendment in 1868 and subsequent judicial interpretations, which made clear later that the Bill of Rights, by use of the 14th Amendment, also protected rights against state encroachment. But originally, it was just the limitation on federal power. It's only largely in the 20th century and now thereafter that they've been understood as restrictions on the states as well.
That's what was going to be my next question, is how has that evolved and changed? How do we think of them now?
I mean, now we think of it as restrictions both on the states and on the federal government. As I said, this is largely a function of judicial interpretations protections of the 14th Amendment, which protects life, liberty, or property without due process of law. The courts have said that the protection, virtually all of the protections of the Bill of Rights are incorporated, the technical term, incorporated in the Due Process Clause of the 14th Amendment. So since more or less the 1920s or 30s, we have understood, and the courts have understood, that pretty much the same protections apply against the states as apply against the federal government.
Okay. In looking at the freedom of press issue, we are all very alive right now to an issue which has been much in the progress. Albemarle High School had a young woman who wrote an editorial in which she suggested that perhaps student athletes didn't need to take PE. The principal of the high school had some objections to it, as everyone knows, cited some typos, some various other reasons not entirely disclosed. The paper ran minus the article, and the young woman was alleging that her right of free speech and freedom of the press was violated. There have been back and forth editorials to the progress. Again, one gentleman wrote in and said, well, actually, the school functions like an employer, and therefore there is absolutely no reason why, since they have dress codes and other rules, we can't they cannot restrict the students' speech. John Whitehead recently had a piece in which he talked about a dangerous, increasing sense of authoritarian, which is creeping into our schools, and that is a microcosm of what's going on in the country. So, having said all that, what do you think, pro and con, about this issue? Does the principal in the school have a point? Does the editorial writer have a point?
Well, there are the First Amendment itself, as with most of the amendments on most subjects, doesn't answer the question. Might be useful to point out that the United States has roughly the shortest constitution in the world. And by virtue of being short, it's vague, it's open-ended, it doesn't answer a lot of questions. The U.S. Constitution is about 12 pages long, Constitution of South Africa about 110, Brazil about 240. So we have a constitution with very little detail, and it's up to the courts to fill in the blanks. On the question of freedom of the press, things are no different. The blanks have been filled in terms of student speech and student press only 4 times. The Supreme Court has decided only 4 cases dealing with student free speech rights. One was a case called Tinker versus the Des Moines School District in 1968, protecting the rights of students to wear protest armbands in class. There have been 3 cases since then, and only 3 since then. One upholding a school's right to discipline students who used off-color language in campus, school political campaigns. One very recently upholding the right of a school to discipline students who engaged in, drug-related protests. Bong hits for Jesus was the actual sign that the students displayed. And in between those, there was a case dealing with student newspapers and dealing with the student press, in which the Supreme Court said on the facts of that case, that the student press or student newspapers in that case were largely part of the curriculum, and the ability of school administrators to restrict the content of student newspapers was not dramatically different from the ability of school administrators to give students good grades or bad grades, depending on how they performed in written exercise. Now,
do you think I'm sorry, go ahead. I was just thinking, is this an issue, do you feel, that is going to continue to come up? Because it would seem that way.
It comes up a lot in the lower courts, and the Supreme Court is very reluctant to decide cases dealing with it. It's one of the most commonly litigated issues in lower courts. That is, student speech, student dress, off-color T-shirts, Nazi T-shirts, Klan T-shirts, sexually suggestive apparels, student protest, and so on. The Supreme Court, as I said, decides roughly one case every 10 years. So it remains somewhat of a gray area. The lower courts are all over the map. If it were at the university level, it's clear that the student press would be treated as the press, even in a state university. There are also Supreme Court cases saying that the university-based student press has most, if not all, of the protections of the independent and private press.
That's interesting. So younger people are actually penalized.
I don't know. Penalized is not a word I would use in this context.
Okay.
There is a distinction in terms of all dimensions of academic freedom between the primary and secondary schools on the one hand and colleges and universities on the other. There are things that I am constitutionally protected in saying in class as a professor at a state university that I would not be protected if I said them in class at the primary and secondary level. This distinction between primary and secondary and university applies to teacher speech, student speech on the basis of the existing doctrine, student newspapers. Exactly how this newspaper would be treated, I'm not sure. The Supreme Court's one school newspaper case was somewhat case specific, so we can't tell. But there is a difference between universities on the one hand and junior high schools, and elementary schools.
That's really fascinating. I'm afraid personally I would come out on the side of the kids on this because I think they're our future leaders and citizens. But also in the news recently, there was something in USA Today about a young man, 13-year-old, 7th grader, who wore rosary beads outside his shirt in honor of a deceased family member. It was interpreted potentially as a gang symbol by the school. His mother alleged his free speech and free expression rights were violated. What do you think about that?
Again, the cases on student apparel, some of them dealing with gang apparel, some Nazi apparel, some sex-related apparel, some Klan-related apparel. There's never been a Supreme Court case on the issue other than just a protest armband in 1968. The lower court cases go both ways depending on particular facts, but the more often than not, the ability of school administrators to restrict is upheld at the primary and secondary level, even though not at the university level. Obviously, when it's rosary beads, there are different issues of religion and freedom of religion that might come in, but just the ability of schools to restrict student apparel that students claim to be expressive is a very frequently contested issue. If it's outside of the school, there's no question whatsoever that students and teenagers, like everyone else, can wear whatever they want. Once they're inside the school, the authority of the school administrators wins more often than not.